Thanks everybody. We'll start our eighth session at this conference, and the title of this panel is "Looking at the Bigger Picture." So our first presentation will be by Dr. Ellen Tzvika Nissel. Nissel is a legal scholar specializing in state responsibility with a focus on its historical origins. He teaches international law at the Pepperdine Cardozo School of Law, where his research centers on the doctrine and practice of international law enforcement. Prior to his academic career, Professor Nissel worked as a real estate practitioner and equity research analyst, following the 9/11 attacks. He left the private sector to clerk for the Honorable Justice Eliezer Rivlin of the Supreme Court of Israel. Professor Nissel holds a doctorate in international law from the University of Helsinki, where he studied under the supervision of Marty Koskaniemi. So that's great. And his presentation will be Lex Lata and the Duality of International Humanitarian Law.
Thank you to Yuval, Danny, and Alfit, and the rest of the crew here at the Minerva Center. It's a treat for me to present my talk here on the duality of international humanitarian law. This idea has been marinating for me in my brain, like similar ideas have been marinating in yours for about 439 days. And so this is the first draft of those marinations. So have we gone mad? That's how it sounds. As recently as the 20th of September this year, after the beeper and walkie-talkie strikes, Iran condemned Israeli madness that crossed all lines. Has Israel crossed a red line, or has international law crossed one? Is it, as Fuad Zarbiev claims, that international law has now arrived at its Nicaragua moment? Or is it the other growing sense that the so-called Israeli or pro-Israeli side feels that the emperor has no clothes, that, as Eugene Kontorovich writes, the ICC's anti-Israel biases have finally been exposed. Even Daniel Haas of the Human Rights Watch is criticizing Amnesty International's report on Israeli genocide as a descent into McCarthyism. I don't think that we're all going mad, but I do think that the application of international humanitarian law to Gaza is quite confusing. So to be sure, the post-October 7th war is challenging the integrity of certain legal doctrines. At the same time, it is also clearly constraining conduct of the IDF, as we heard yesterday from Brigadier General Roni Katzir. I reconcile these conflicting impressions by contrasting the practice of states in war to the codified doctrine of international humanitarian law. There is a duality of doctrines in international humanitarian law. One is codified and the other is not codified, but it is consistently practiced. And this conclusion dovetails with one that I draw out in my book about the codified and uncodified doctrines of state responsibility. And I will shamelessly plug it. It's coming out next month. And if you buy it in bulk, it's only $120. If you buy it individually, it's only $150. I problematize there the traditional histories of international humanitarian law that track the codification of the laws of war with the overall institutionalization of international law. Specifically, the traditional history portrays the prohibition of the use of force and the regulation of warfare as originating in the codification efforts of the 19th century, beginning with the Lieber Code of 1863 and going through the Hague Regulations and the Geneva Conventions and the additional protocols, and then the institutionalization narrative that parallels that trajectory from the Permanent Court of Arbitration to the League of Nations to the United Nations and ultimately the International Criminal Court. I critique this narrative as missing the mainstays of international practice. In my book, I do this for investment protection and state responsibility, and today I'm applying that methodology to critique the laws of international humanitarian law, which are based on this traditional history of codification and institutionalization. The history misses much when it comes to the law of reprisals in particular. One reason for the gaps in international humanitarian law is enchantment. As David Kennedy writes, those seeking to bring law to bear against warfare have also enchanted their tools, overestimated the significance of legal pronouncements, and mistaken legal warfare for humanitarian warfare. That's one explanation for the gap that I'll get back to later. Another explanation, maybe an easier one to understand, if maybe a little bit more cynical, can be seen in the Global Peace Index. We all hate numbers, we're lawyers, but numbers are easier to understand than concepts. And when you look at the Global Peace Index, you see that there's an unsurprising correlation between states that are parties to certain treaties, such as the additional protocols and the Rome Statute, and the level of peaceful existence that those countries enjoy. Only one country in the bottom 50 of this index is a party to an international war, or is a state party to the ICC. That's the state of Palestine. And only one other is a state party to the additional protocols, Russia. Yet it is the top 100 peaceful countries, the ones with little knowledge of warfare, or relatively little knowledge of warfare, that are effectively dictating how and when wars should be fought. So there are many controversies surrounding international humanitarian law. Today I'm focusing just on reprisals because it's impossible to do much more in the time given. And I'll be discussing the gap between the humanitarian requirements under the Geneva Law and the military practice under what we call, or what I'm calling, the Gaza Law. And specifically when it comes to reprisals, these are uses of force by states that would normally be illegal, as we know, but are permissible when they are employed in response to an unlawful act. My terminology here is a little bit loosey-goosey, so pardon me. I'm just trying to make a point about reprisals. And there are generally two kinds of reprisals. There are armed reprisals that generally mirror and parallel the laws of use ad bellum, of the laws of use of force. And then there are belligerent reprisals, which are generally associated with the laws of war, the use in bello. Both forms of reprisals are actions that are more about enforcement than they are about self-preservation. As Professor David Kretzmer notes, self-defense is defensive, whereas reprisals are retaliatory in nature. Professor Kretzmer offers three reasons that distinguish between these two concepts: the absence of an armed attack, the punitive nature of the action, and the timing of the action. Obviously, this is a larger topic, but some examples of reprisals to get the juices flowing are, for example, the Israeli military responses to the rockets being flown and drones being flown into its country. Yesterday, Ukraine killed Russian General Igor Kirillov in Moscow for ordering the use of banned chemical weapons in the Ukraine. So this is obviously a widespread and ongoing practice. Just read the news. Evidence of reprisals can be gleaned both from military practice, the Wall Street Journal, and international jurisprudence. And some patterns and principles can be gleaned from this practice. For example, as Professor Kretzmer wrote, since the purpose of reprisals is enforcement, reprisals may not be retributive. They must be necessary and proportionate to their prospective goal, and they may not target civilians. Okay, so reprisals have been around for a long time. Have to give it a brief history, very brief history. Very brief history. Before the creation of the modern doctrine of state responsibility, international law permitted states to make recourse to war and make use of reprisals to enforce their international rights. Most enforcement actions occurred through these privateering rights and issuances of letters of marque, as opposed to war. War was an option, but private enforcement was more frequent. But by the 19th century, reprisals as a private form of enforcement came into desuetude. Politically, states increasingly took it upon themselves to control their own borders and control the interests of their nationals abroad. Diplomatically, the 1856 Declaration of Paris entering the Crimean War was the official death pronouncement of privateering. And legally, the rise of international litigation, including arbitration, establishing the modern field of state responsibility, became the legal framework for international dispute resolution. as the doctrine of state responsibility grew in use and importance, it was hoped that there would be less of a need for war and reprisals. Indeed, the vast majority of the early recipients of the Nobel Peace Prize were associated with the peace movement and the international arbitration movement. The League of Nations and later the United Nations grew in size and in diversity, and when this happened, they began in earnest to flesh out principles and codes of state responsibility, especially after 1930. But the main source of this new field was the American practice in the New World, which was tainted with a color of imperialism, and as a result, codification efforts in the United Nations were based not on the actual American practice, but on the state responsibility treatments in German and Italian theories. Namely, state responsibility as a doctrine of international dispute resolution became divided into three parts: principles of attribution, determining the content of state responsibility, and enforcing that state responsibility. So the principles of attribution would be those procedural principles that attribute the wrongs to a state. Then, if that wrong can be attributed to the state, what is the content of that state responsibility? Is it reparation? Is it cessation? Is it compensation, restitution? That was the content. And the third element that came out of this systematic treatment in German and Italian literature was the enforcement. That was still a mechanism of self-help. How did you enforce the content of that state responsibility? This tertiary element of state responsibility was the most difficult to codify in international bodies, since it involved the viciousness of reprisals and war. And therefore, reprisals were excluded from the modern doctrine. Here goes the shameless plug. So, when the articles on the responsibility of states for internationally wrongful acts, or as it is ineloquently referred to, RCWA, were finalized in 2001, it excluded all manners of forceful enforcement from the draft. As a result, the nature of reprisals as a form of self-help or international enforcement has largely been understudied. All eyes on codification, all eyes on the ILC, the codified doctrine. Instead, many international lawyers have come to think of the use of force as the modern rules regarding war, which has nothing to do with state responsibility and is imprecise and misrepresentative. Since World War II, war has been prohibited as a peremptory norm of the international order, but while the UN Charter also permits certain uses of force, whether under Article 51 or Chapter 7 of the UN Charter through the Security Council, it says nothing in the UN Charter about reprisals. Thus, the law of armed reprisals remains largely uncodified by both the UN Charter and RCWA, and I'll discuss belligerent reprisals in a moment. The ILC justified this exclusion as saying that when it comes to the laws of war and the use of force, that's a lex specialis. That's a special set of rules that has to do with primary norms. It's nothing to do with the enforcement regulations that has to do with state responsibility. So over the past 75 years, the relationship between the use of force and state responsibility has continued to be described as being without prejudice to the other. This is, again, misleading and has led some commentators to incorrectly claim very recently that violations of the law of war only trigger individual criminal responsibility and not state responsibility. More on this later. As regards to belligerent reprisals, 20th century efforts to codify an institutional international humanitarian law also limited them in earnest. The 1929 Geneva Convention regarding POWs, the 1949 Geneva Conventions, and additional protocols to those conventions, especially with regards to non-combatants. And there are several dozens of United Nations Security Council's resolutions condemning reprisals by several countries, including the United Kingdom, who abstained from a resolution criticizing its own reprisals against Yemen. Right? That was the day. That was back then. So some, like Professor Michael Schmidt, have argued that the prohibition of reprisals is clear enough and no longer allows for any exceptions, and we should not allow for any exceptions because the floodgates argument. Nevertheless, the practice of reprisals has persisted. For example, in 2021, after non-state actors attacked the United States and coalition personnel in Iraq, President Biden directed armed reprisals to be taken against infrastructure of that group in Syria, President Biden justified these reprisals as necessary and proportionate actions taken out of self-defense in order to prevent future attacks from a state that was unwilling or unable to prevent them. So this inconsistent state practice is not negligible and continues to be justified by states based on notions of self-defense. As mentioned, David Kennedy explains this mismatch between duality of doctrines and practice as a result of Geneva lawyers being enchanted with their tools and having overestimated the significance of humanitarian codes with the reality of legal warfare. But in the dark side of humanitarianism, he further explains the resilience of the Gaza practice, as opposed to the Geneva doctrine, by describing reprisals as an orphaned doctrine, meaning in the 19th century, reprisals were justified as a lesser form of war when war was permitted as a means for resolving disputes. But in the 20th century, when the legal and political landscape shifted due to the changes in international institutions, etc., and the turn to international arbitrations, what we see is a pushback from these newly recognized states against the practice of force to resolve international disputes. This pushback originated in Argentina with lawyer diplomats like Carlos Calvo and Luis Marie Drago, who articulated doctrines of prohibiting force as a means for protecting their nationals abroad. And throughout all these and later limitations of war, positive law remained ambiguous on the issue of reprisals, which became a legal relic of a bygone era. It persisted and it was significant, but it wasn't discussed in the positive law. But if you look at the Department of Defense Law of War Manual, if you look at the United Kingdom Law of War Manual, they both take positions that the additional protocols absolute protection and protection of civilian and rejection of reprisals is counterproductive. Time to recapitulate in the 5 minutes we have left and give you some practical takeaways. In this paper, I explored a doctrinal duality of international humanitarian law with an emphasis on the law of reprisals. By contrasting codified norms and their practical application, I see two distinct doctrines of international humanitarian law. Whereas Geneva law is largely approved by the vast majority of states around the world, Gaza law is practiced by a handful of states who have fought prolonged wars in the past several decades. So why the gap between Geneva and Gaza? The answer has to do with what is so fundamentally and singularly controversial in the nature of war. In contrast to lesser controversial areas of international law, the successful codification in Geneva can be categorized as a form of lex spei, a law of hope, while lex ferenda suggests an active proposal or advocacy for a specific future law, a progressive development of the law. The lex spei denotes a determined hope for a legal principle or standard without necessarily being tied to a pattern of state practice. While much has been written to contrast lex lata, existing law, from lex ferenda, a progressive future law, this paper seeks to contribute to this discourse by introducing the concept of lex spei as a way of describing how far removed the codified doctrine of international humanitarian law is from the actual practice of Western militaries, such as the IDF, in part. The laws regulating recourse to force in international humanitarian law are not simply a lex specialis of state responsibility that were excluded from the 2001 Articles on State Responsibility for convenience. It was a political decision by the Italian jurist Roberto Ago to repress the weak relationship between doctrine and practice of international law enforcement. And the separation has reached the point where the conduct of war crimes have come to seem like ultra vires acts that cannot even be attributed to states and only to individuals. The result is neither obvious nor inherent to the field. It is a Geneva preference that arose in the aftermath of World War II, and especially in the post-colonial context, and the turn to international institutions by the non-aligned movement, whose preference it is to speak in terms of self-determination and resistance rather than sovereignty and self-defense. This is particularly unproblematic for the vast majority of states, the top 100 states, especially European ones, as they have experienced a golden age of peace since World War II. Professor Kressmer, second quote from him, eloquently refers to this as the rhetoric of unaffected states. It is easy for the top 100 in the Global Peace Index to sing the song of peace when there are no rockets firing across the borders. For the several states in the bottom 50 countries, such as Israel and the US, the applicability of the codified international humanitarian law to their armed conflicts is problematic. And that's why I will end this presentation by offering several serious consequences to the conclusion that IHL is a species of the lex spe. Fair labeling. So a few. Is that fair labeling? So, identifying international humanitarian law as a lex spe adds a measure of honesty and fair labeling to the field. The traditional view that the prohibition of force is a peremptory character is true, but saying that alone is misleading because the right to self-defense is just as much as preemptory norm. As Nicholas Tsagorius explained yesterday, the right to self-defense is not an exception to the rule prohibiting war. Both are primary norms of international law. When a security threat falling short of an armed attack occurs, messaging Antonio Guterres, the United Nations Secretary General, on WhatsApp will be of limited use. As long as there's no international police force or 911 to dial in case of emergency, states will retain their basic right of self-preservation. So fair labeling is important. It is what it is. Breach of legality. The gap between the doctrine and practice also opens the door for the ICC to undermine the prohibition against ex post facto law known as nullum crimen sine lege, no crime without a law. This protects individuals accused of war crimes from punishments for conduct that was not clearly criminal. I missed the 2-minute warning, sorry. Was not clearly criminal at the time. Sorry?
I didn't give it.
Oh, okay. I'm not that crazy. I'm mad. Anyway, so sometimes, perhaps in the case of unclear legality or mistaken war crimes, it would be preferable only to impose state responsibility. Other times, it might be more preferable, for example, in cases of kidnapping and rape, to impose individual criminal responsibility. It's time to think about the relationship between these two regimes. Legitimacy crisis in the IHL. People are commenting that the ICC is prosecuting all sorts of things in a discriminatory manner. I'm not going to get into it. I'm just going to say that aligning doctrine and practice will increase compliance-able and perceived legitimacy of international law institutions, including the ICC. And finally, and perhaps my most important point I'll leave for last, ethics beyond compliance. Allowing for flexible and open interpretations of an international humanitarian law will create room for an important dimension that has been missing from the conversation: ethics. In fact, overly technical calculations of military conduct, such as death counts, distort legal concepts such as proportionality, as Klaus and Gall discussed yesterday. Introducing ethical norms into the discussion not only adds nuance to IHL, but allows us to move beyond issues of compliance and legal analysis and into more honest and no less influential forms of normative critique. Going back to the pre-additional protocols era and the discussion of IHL in Israel, it was triggered by Professor Yeshayahu Leibovich in the wake of Kibia affair in 1953. That was a time when the question wasn't simply about compliance with IHL. It was about exceeding those minimal standards of care because our own ethical norms surpass those and stem from our history and the Talmud. Hence the image on this slide. Otherwise, the alternative may be the realization of the narrative presented earlier by Amir. Thank you.
Thank you very much, Alan. And now we're moving to Professor Yair Listokin. Yair is a Deputy Dean, Shibli Family Fund Professor of Law, and Director of the Brody Center for Jewish and Israeli Law at Yale Law School. He studies tax law, corporate law, and Jewish law from economic and empirical perspectives. In his book, Law and Macroeconomics, Legal Remedies to Recessions, by Harvard University Press, Professor Listokin argues that law offers an underdeveloped but desperately needed tool for stabilizing economies when monetary and fiscal policy prove inadequate. Professor Listokin has been honored as a distinguished fellow of the Hebrew University School of Law, a Milton Freedom Fellow of the Baker Freedom Institute at the University of Chicago, and has served as a visiting professor at Columbia Law School, Harvard Law School, and NYU School of Law. His research has been featured in Wall Street Journal, New York Times, CNN, and the Boston Globe. Thank you.
So the kind of the starting point for my talk today is the notion of double standards at the UN General Assembly or at really anybody involved in international law. So there's, I think we intuitively get why double standards are problematic. They're antithetical to the rule of law, but they're ubiquitous. So quoting from like a recent observer saying that diplomats are regularly accusing each other of double standards. It's kind of the coin of the realm. And in part because of this, what we get is kind of, distinguished observers saying like, we don't take claims about double standards too seriously. It's just rhetoric. And I think, and in fact, Israel has been on both sides of this double standards debate, that it's subject to an overly critical double standard, that the West is using some of its power to protect Israel from behavior that would be problematic otherwise. So I think you all know that background. What I'll just say is that, like, to say that we don't take claims about double standards seriously, I think is like an abdication of responsibility. It would be like saying that, we don't take discrimination claims seriously in the US because a lot of people make them. No, that's too easy. It'd be nice that way, but you have to do better. So how do we avoid mudslinging? I'll argue that one possibility is to try to establish a kind of a basis of fact, and in fact, empirical methodologies I think are useful along a number of dimensions. Number one, it kind of gives you like a broader perspective on the problem. It's not the correct perspective, but it's a different perspective. Second, I think it's much more helpful. Rather than accusing each other of dishonesty or bad faith, to turn it into a discussion about methodology. Like saying what's wrong with the specification, I think is a much more productive conversation. And finally, I think it's empirical papers. Like the line is, don't trust papers, trust literatures. Any one paper can never be definitive. It's always subject to problems. But if you see 200 papers that have different problems but are broadly pointing in the same direction, well, that starts to tell you something. Okay. So this is a broad methodology that can be applied to double standards in general. I'm going to apply it to UN General Assembly criticism of Israel, but that's my example. This is a much more general methodology. I'm also going to hopefully convince you that ChatGPT can be a really useful RA for evaluating international law without at scale. Okay. The methodology I'm going to use is something called the Blinder-Oaxaca decomposition. This is a workhorse in the economics of discrimination. So it was developed, the idea being you have, the classic example is black and white wage differentials in the United States, or male-female wage differentials in the United States or anywhere. And so we have differentials. The question becomes how much of the differential is due to discrimination, and how much of the differential is due to explanatory variables, observed variables. This is a method of decomposing, of kind of saying like we can explain this percentage of the difference, but we can't explain that percentage. Adding up to 100, of course, it could. Sometimes you can explain more than 100% of the difference. You can explain 150% of the difference, or something like that. One kind of nice thing about this, in addition, is that it allows you to kind of build a model on. So, like in the wage context, with like black and white wages, you kind of build a model of wages as a function of education, experience, et cetera, on the basis of, let's say, like white Americans. And then you could take that model and then apply it, that you've developed kind of independently of that. You can then apply it to black Americans and see how much do these explanatory variables explain. And then the remainder we'll say is unexplained. I want to caution everyone that technically it's unexplained. It could always be the case that the unexplained part is not that it's discrimination. It could be, I'm missing a variable, I'm missing 2 variables, I'm missing 100 variables. So part of the conversation is what variables to include or not include in the regression. So that's the regression being the means by which we kind of estimate the relationship between observed variables and outcomes. And so I'll say, like, when there's a lot of unexplained variation that supports claims of double standards and discrimination, it doesn't prove them. And as I said, this can be applied generically to any debate about double standards. Okay. So speaking of which, what are the variables that I'm going to use as my explanatory variables? So my outcome variable, the thing I'm seeking to explain, is the average number of annual critical UN General Assembly resolutions about a particular country. So I take like the list of UN General Assembly countries. I don't have them all. I have like 190 something, and I estimate how many times the UN criticizes them per year in a particular resolution, and that's the variable I'm seeking to explain. Okay, what are the variables that may explain why countries might have a different number of annual critical resolutions? So one thing I want to emphasize is I'm focusing on country fundamentals. One thing you could do is take like New York Times headlines and stick them in the regression. But of course, that itself may be subject to a double standard. So I'm trying to look at, as close as I can, get down to behavior. Facts as close as I can, rather than kind of interpretations that may themselves be subject to the same problems. But you'll see it's very hard to do that perfectly, and I'll talk about that. Okay, so some things I take are like demographic variables, like population, per capita income, things along those lines. Other variables I take are like geopolitical, like who are your allies, what's your role at the UN? Are you a member of the OECD? Israel's kind of convenient there in that there's variation in its OECD membership. I also take something from a consortium of scholars called Human Rights Scores. This is available since 1981. They basically go through country after country, try to give a score. Here, this is the area where I'm most concerned that, this is not given. I think many people could look at these things and come to different scores. So take this with a grain of salt. But it's something that has been kind of focused on and validated. I think it has some correlation with reality, but don't take it too seriously. I have variables on like whether a country is occupying another country's territory or territory that's not its own. I have variables on whether a country possesses nuclear weapons that are not recognized in the Non-Proliferation Treaty. I have conflict variables from the Uppsala conflict data program. So they measure like the number of conflicts the duration of the conflicts, the number of annual fatalities in the conflict. They have a bunch of different measures of that. And then in some specifications, I'll look at, I'll try to control for region. I'll try to control for years, because the UN General Assembly has its own patterns, and I'll talk about interaction terms. I can also kind of control for if someone wants to say that Israel is behaving a certain way and it's a U.S. ally, and it's that combination that is causing something. Well, that's something we can adjust for. That's an interaction term in a regression. Okay, all right. So one point to make, though, is how do you determine how many annual critical resolutions there are? It's not easy. So it's easy-ish to obtain the text of UN resolutions. It gets increasingly hard as you go back in time, but okay, that's a solvable problem. What's hard is you can't just count references. Because there are, you want critical references. So for example, like Palestine is very, very regularly referenced by UN General Assembly resolutions. And I think most people would say those are not critical. Every now and then they can be, but for the most part, that's just not the case. So you want to kind of interpret the resolution, not just count number of references. So that's hard work. So the UN Watch, the NGO UN Watch, has been doing something along these lines for the UN General Assembly and other bodies of the UN since 2015. But that's since 2015. I'm trying to go back much farther. So what do? So I kind of feed the text of every resolution passed since 1981, when my key control variables start going. I feed that into ChatGPT, kind of ask it whether it thinks which country is being criticized in this resolution, if any. But I can compare the results that ChatGPT gives me for the post-2015 era with UN Watch's determination, and they kind of cross-validate. So UN Watch is being cross-validated by ChatGPT and vice versa. Okay, so what does that look like? Okay, so this is, so here we have on this side here, these are UN Watch's determinations. Again, this is only looking at 2015 to the present. Okay, so there's a lot of resolutions. Most of them don't condemn Israel. And then down here, this is what ChatGPT says. Okay, so in this box, what we have are resolutions that UN Watch determines don't criticize Israel, and ChatGPT determined don't criticize Israel. In this box here, we have the diagonals show this is something that Israel is a resolution where Israel is being condemned by the UN General Assembly, and ChatGPT says that Israel is being condemned by the General Assembly. On the off diagonals, there we have the misidentifications. So here we have Israel is condemned, and here we have, but ChatGPT says no, and here we have the opposite. And I've looked at these, and I kind of see it both ways. I think you could reasonably go either way. Okay. So I think this is a pretty good validation of ChatGPT. One common kind of classification task score. Okay. One common classification task score is it gets a score of 0.9. Okay, so enough about this. Let's get to the results. Okay, so first of all, just summary statistics. Summary statistics. One thing to point out: the key line here is the first line. So since 1981, Israel is the subject of an annual average of over 19 critical UN resolutions. The average country is the subject of 0.2 per year. So it's 2 orders of magnitude. It's practically unprecedented. The only precedent is South Africa in the 1980s. That is it. Israel was is about equal to South Africa in the 1980s, and just kind of continues at that rate throughout. There doesn't seem to be a real pattern in the numbers controlling for UNGA general activity. Okay, so that's key, and these are my control variables. You can see. So Israel's been occupying. Most countries are not occupying. Israel has nuclear weapons outside the NPT, allegedly. Okay, so here we have like the regression model. So this is trying to take, excluding Israel. We exclude Israel. What predicts UN General Assembly criticism? So what does? So you can see, in general, I wouldn't say it's a great model. Not much is the truth. So higher human rights scores reduce the number of critical resolutions, although this is quantitatively not that big of an effect. Being a Security Council member increases the number of critical resolutions, while this is not statistically significant, South Africa in the 1980s had nuclear weapons outside the NPT. They had kind of an off-the-charts number of resolutions. So empirically, this is a huge effect for this. These specifications, by the way, are in logs. I'll show you. Here it's in levels, right here. So if you have a nuclear weapon, you have 3.6 resolutions, critical resolutions about a year. That's on a base of 0.2. So it's enormous. Okay. And then finally, this is kind of what we've all been heading to. So how much of the total difference in annual resolutions can I explain? So about 15%. Now, that's very noisy. And it's overwhelmingly due to the nuclear weapons thing. So nuclear weapons outside the NPT, very rare. One of the examples in the kind of control sample is South Africa, which was also the subject of many, many resolutions. So that is doing the overwhelming majority of the work. All the other variables, Israel's human rights score, occupation, all of that doing very little as an empirical matter, just because other countries that occupy land are not the subject of additional resolutions. So the difference to be explained is 19 point something, and you can see based on the specification, I can explain about like 3 and change, leaving 15 and change as unexplained. So the unexplained, that is statistically different from 0 at like the 99% level. So I'm pretty confident that all the observables I had, including interaction terms, which I didn't mention, I'm pretty confident that they don't explain the difference. So I would say the results are quite consistent with the existence of double standards, that they don't prove it. We could talk about variables, I'm happy to, but they're noisy. There isn't that much data in the regression, so you can see the standard errors are quite large, meaning like we shouldn't be all that confident about this result, but it's something. It's something we can debate and hopefully improve. And it's that kind of methodology and approach that I really want to push forward, as much as that it's 3.5 rather than 2.5 or 4.5 or something like that. So thanks so much, and I look forward to your questions.
Thank you very much, Yair. Thank you. So our last speaker will be Professor Rachel van den Lingen. Is the Irwin Buchalter Professor of Law, Associate Dean for Research, and 24-25 Kenneth and Harold Montgomery Foundation Scholar at Southwestern Law School, Los Angeles, California. She currently teaches criminal law, criminal procedure, international humanitarian law, and national security law. Prior to teaching, Professor van den Lingen served on active in the U.S. Air Force for 24 years, including more than a decade as a judge advocate with tours focusing on both criminal law as well as the law of armed conflict. As the legal advisor for international law at headquarters, U.S. Central Command, she advised on operational and international legal issues related to armed conflicts in Afghanistan and Iraq. She was also the command's first formal liaison officer to the International Committee of the Red Cross, so all are relevant. After leaving active duty, she led the National Institute of Military Justice, the only nonprofit dedicated to the fair administration of U.S. military justice. And I will go, and she is the author of many publications, and we are looking forward to your presentation. Thank you.
But first, my utmost gratitude to the Minerva Center and the wonderful human beings that work here, from Yuval, Yael, Danny, the terrific Nofit for her flawless organization, etc. I apologize for not having my draft paper done in time due to my own, that's only to my own detriment, and my own personal challenges. And is the Slido operated? Is it on? Okay.
I turn it on, but you can make sure if you want to.
So this has to be clicked on.
Okay. Let me see. Yeah. Give me a second then. Sorry. Technical difficulties.
So I am merely outlining for you my draft article, and if you squint closely enough and hard enough, hopefully you'll find the contours of a book proposal in the following rather excited and far too jam-packed overview. I do hope this work in progress will be both a law review article for hopefully, if I'm honored in the Israel Law Review, and as to do double duty as an introductory book chapter. If you feel that I have enough here to actually proceed, thank you. We'll see if that actually works. So without further ado, thank you for everything I've learned from the previous speakers who have been absolutely marvelous yesterday and today. I'm honored to be in the same area as you. And instead of asking you all to set aside your emotions right now, as we've been asked to by previous presentations, I'm humbly asking you to notice them in the law, notice them in how the law is discussed, notice them in others as the law is interpreted and applied. And I make this ask for you to notice emotion with some fears coming across as insensitive, because I'm not blind, of course, to our greater context here. Indeed, my project of examining the role of emotions in the law of armed conflict, which I'd previously started well over a year ago, but set aside in my growing waste can of that I call I'm not qualified to do this waste can. Well, I will start projects and then lack courage and conviction and feel unqualified. I took it out of that waste bin as I watched with horror and felt deep sorrow regarding the atrocities committed on October 7th and the tragedies that have unfolded. And I've watched that and witnessed the immense suffering of my colleagues and my friends and everyone here and around the globe. It is my premise that not only does emotion affect the law of armed conflict, emotion is actually part of the law, and the law produces emotion as well. So despite the pain that comes with this endeavor, exploring the role of emotions in and around LOAC IHL is illuminatory and critical to a fuller understanding of this body of law, and frankly, all of law as the social construct that it really is. And so that I don't forget I need to personally thank Yali Sherevshevsky, because it was his post almost exactly a year ago in Just Security that gave me the courage to not abandon this project and reminded me of how necessary it is, so thank you. So at the risk of sounding trivial, or making this trivial, which I don't want to make it, I point to the slide here. Are emotions really silly to examine? Are they as useless as wings to penguins? Because certainly penguins don't fly, and that image is AI, I believe, AI generated. In fact, is the law cold, and should it be cold? Or do these wings actually serve a vital purpose? Do emotions serve a vital purpose in, of, and about the law as powerful engines for propelling the law, as wings actually propel penguins underwater, where they do, in fact, seem to fly. So just as emotions help us make meaning of the world, I believe that emotions help create meaning for the world that LOAC is indeed created for. So with that, I was hoping you could quickly take out your phones if possible, and use the QR code. And if the QR code doesn't work for you, if you go to the URL slido.com, and it'll ask you to punch in a number, you'll be able to take this question and to answer it. So actually the question is, does the label international humanitarian law make you feel differently than either the label, the law of armed conflict, or the law of war? Yes, no, sometimes, or this is a stupid question. I intentionally did not put in all of the above because that's a cop-out. So once we're able to do the first question, if it's actually working, the other questions will go much more quickly. Does anyone give me a hand that they were actually able to do this successfully? Oh my God, technology works. I don't trust it. Yes, but then defer to that. Okay, so yes, 64%. Oh, thank you for the 0 on stupid question. You're very kind because I probably deserve it. Let's go to the next one. Using 1 or 2 words, but the caveat, as many as you want because of Article 19, the ICCPR. I will not restrict your expression. What is an emotion? It's my biggest definitional dilemma, and it runs throughout the literature in this area of law and emotions. I'm not going to give you time to write a treaty, so despite Article 19, I will violate that. For sake of time, let's see. Okay, inner feeling, reaction, raw feeling, speech, subjective feelings, the way you feel, internal reaction, again, motivation force. Feeling being the most predominant. Felling, I'm assuming that meant to be feeling as well. But you're lucky I disabled the option of identifying the input of who you were, so I made it anonymous. Okay. Do emotions have a role in the law of, have a role in the law of war? That is LOAC, the law of armed conflict. Yes, no, it depends. And again, this is a stupid question. It immediately went to the answers. It depends. We're still coming. Okay, I'm keeping you awake right before lunch. God bless you. Okay, finally, what role should emotions play? The normative question, the law of war or of armed conflict. And this is really more of a theoretical question, but I think I did give you space to try to answer it. But it's a much harder one, and so I really don't realistically think you could, but I wanted to throw it out there because I need your help in helping answer this question. Moral support and balance, compassion and motivation for peace. It should ideally not, but do in the real world. It's complex. It's for victims. None. Okay. Thank you. Should curb emotions, nurture some others. It should play a profound role. Numerous no role. The law should be objective. Excellent. Thank you so much for your, I didn't mean to go that, I think I accidentally clicked that. I didn't mean to go so quickly to this next slide, but I wanted to thank you for your participation and engaging with us. And as I start out with my overview of what started to be just one paper, but I realized is actually a book, and so my first paper actually will be the introduction and just outlining all these, what this endeavor actually is. I wanted to outline a few myths that I have learned from our sister sciences, both hard and soft, including cognitive neuroscience, as well as the cognitive psychology, cultural studies, et cetera. There is actually the myth that runs deeply throughout the Western world, from philosophy to ethics to law to economics, is that there's actually a division between emotions and reason, when there's actually resoundingly no, as much as the world is round and it's not flat. There is no true division except a very artificial, inaccurate, and superficial one between emotions and reason, and I'll explain to that in a little bit. Another myth, that law is actually objective and neutral, and therefore it's rational and cold. Another myth, that law works actually by suppressing and regulating emotions. It's all about that the emotions being down in that reptilian part of our brain, the limbic part here, and that we share with all of the rest of the animal kingdom. But we're humans and therefore supreme because we think. Actually, cognitive neuroscience has shown that there is no such thing as just that limbic system, that our brain is defined by plasticity and degeneracy, meaning there's numerous ways for the brain to produce various moral constructs that it puts out, or cognitive constructs on the world. Another myth, that emotions are bodily, as well as much of emotions are feminine. So nothing to do with the hard, cold law of war that is the world of men. And reason is the brain. And in fact, another myth that I challenged you all to consider is that we actually do share a common reality, because reality is actually what we make of it, and what we make of it is how we feel. It's based on our feelings. Again, another myth, that we're actually rational, and that our senses actually provide an accurate and objective representation of the world, that our perception of reality is objective and unbiased. So, where am I getting some of these conclusions, or really a lot of them? I was trying to take an approach of, and I'll explain in a moment, of law and emotions theory, but supplementing it with the greater research that is being done and coming out all the time, which is why I wind up having so much difficulty putting pen to paper, because there's always more books coming out. My sister is one of the chief psychologists on active duty in the United States Army right now. My best friend for decades is also a psychologist, so they're always feeding me so much more information and things to read. But the science of emotions is showing more and more that, basically, what are emotions? First and foremost, there is a definitional dilemma, and many scholars just avoid even defining what they are, and they immediately go on to talk about them. But they are, in my approach, taken from cognitive neuroscience and social and psychology, the affective aspect of consciousness. Affect is what we all have. We can't shut it off. It's this general sense of feeling that we have throughout the day, composed of both arousal, how intense that feeling is, and valence, which means pleasant versus unpleasant. That's actually produced by interoception, biological senses in our body that's regulating our metabolism, and through some magic that actually it produces these feelings, this affect. And emotion essentially are instances of intense affect. Of course, the love, hate, the enmity that we heard so brilliantly described earlier this morning. As emotions. So we have the classical theories of the classical approach to emotions, that is, emotions are prime, and this runs from Darwin to Plato, to psychology and some of the leading psychologists that were foundational in the United States. In the last century, but emotions is primal, physiological in nature, that there's actually a fingerprint that we can find, neural fingerprints for emotions, that they're universal, that all human beings feel them, and they feel them the same way, that you can divide the human beings' experience between thinking, feeling, and acting, and those are three separate components, and that the emotions essentially are evolutionarily programmed bodily responses, they're reactions, they're triggered, when in fact we make them up as we go along. They are constructs, and that's what the cognitive theories are showing more and more today. Emotions are actually evaluative, contextual judgments. They're subjective, they're belief, and they're goal-driven. They are goal-driven constructions of the world. So you have to remember, what is the goal of the party that you're talking to, or that is interpreting the law or applying it, because that is going to affect how they actually consider it and apply it. There's all sorts of internal, fascinating body budgeting processes that go into this that I'll leave for my paper, and I probably need to cut because it's too long for the introduction part. But essentially what you feel alters your sight and hearing. What you feel is based on your brain's predictions and its past experiences and your social, your society, your culture, your group that you've been exposed to since even before you were born in utero. Do you know right now your affect, and it was an Israeli study that was shown by judges who were granting parole or denying parole, and the judges' decisions right before lunch were more negative. So please don't use that against me right now, because they were engaging what is called affective realism, taking what they believe to be their taking their feelings and their general affect of generally low arousal and unpleasantness because they're hungry and they're tired and it's right before lunch, as you're all feeling right now, and saying that's what their actual reality is. It's because this is a bad guy and needs to belong in jail. When that's actually wasn't with the same person in the same case. If they heard it after lunch, we're like, oh, okay, the chance of granting parole was much greater. Just fascinating work that's being done in this area. This goes into it a little bit more, and I wasn't watching my time, and I should. I failed as a professor. Concepts. So what's critically important to much of the cognitive psychology and neuroscience going on right now is this idea of concepts, which is really highly hubristic and arrogant of me to even try to attempt, because it's really about how we think. And there's so much incredible data, entire disciplines dedicated to how we think. But how can the law actually regulate behavior if we don't figure out how human beings think? But this is about categorization based on imposed similarities. We have cookie cutters in our brain of the world that demarcate what's useful for us. And we heard about this earlier in the presentation from our wonderful cultural perspective presenter about boundaries and demarcation and cookie cutters, and feelings and emotions help us. They're a kind of construct. They are cookie cutters that are goal-oriented that we place on the world around us that are directly linked actually to our affect and our general feelings. In fact, emotions are purely mental concepts. They require words because emotions don't exist in nature. Right? Just like money doesn't exist in nature. You can't point to a dollar bill and a shekel and a shell that used to be used and a gold coin that was used as a monetary unit. You know, you have to be able to talk about what the concept of money is using words. Same with emotions. And we group similarity under words to allow us to access information that resides in each other's brains, just like we do with the concept of money. Thank you so much. And I mentioned affective realism. So I'm trying to bring this to bear and using it in what's called law and emotions theory, which has been primarily utilized in domestic analyses in the United States. And one of my dearest colleagues at my institution right now is an international and national leader in this area of work. But law and emotions theory and scholarship has received a bit of attention in the international legal sphere. And we had the wonderful article that I think was nodded to earlier, the Nazma Zadira's article, in which she talks about, she mentions law and emotions theory and says, international humanitarian law, the law of armed conflict, is ripe for an analysis to use the tools from law and emotions theory to actually analyze the law. But then she goes on to say that she was looking at the scholarship, academic scholarship, and the narrative and the words used, and how emotional or emotionless the words are utilized to describe IHL, and left this project to the side. And this is the project that I'm trying to take on. For first of all of the scholarship, the similarity is the foundational challenge to the idea that there's actually an emotion versus reason divide. In fact, emotions are a type of cognition, and they're intricately linked to cognition and can't be divided. They shape the law, and they're shaped by the law. And there's the methodology of there's an illumination, an interdisciplinary investigation, and then an integration, a normative component. So the so what part. Emotions constitute knowledge. By trying to look for emotions within the law and how the law is talked about and how it's interpreted can help us improve alignment of law to human realities. Help us uncover the unknown knowns, those knowns that we are suppressing, as well as those unknown unknowns. And improve, hopefully, the functioning of the law. Okay, so there's a taxonomy. I thought I had to do all of these before I could ever produce a paper, and I realized no, just laying out my taxonomy will be that first paper, which is right now hundreds of paragraphs of a mess. So first of all, emotions about the law. That are emotion producing. We have situating this in the current scholarship. We have scholarship about the language of the law. Naz's article about passion versus the lack of passion when speaking about the law. We have pedagogy. We have Emiliano, who's wonderful, Buis, I think some of you know him. He and Rebecca Sutton have written and spoken about the Pictet competition and bringing in the role of emotions in the interpretation and application of the law of armed conflict as it's being taught to our students, not divorcing it from the actual emotions that are very real and present within the law and the actors that are using it. Lawfare for me is a huge component of how the law is used to intentionally produce emotions in people talking about that are listening to that. Thank you, listening to that discussion. Then we have emotions in the law, and there's really only one paper right now, and this is something I spent much of the summer doing, having my research assistants going through the actual text of the Geneva Conventions, additional protocols, all the commentaries to highlight, okay, where can we find textual components of emotions actually in the law? So things like, of course, humiliation. The entire goal of the law of armed conflict is to reduce unnecessary suffering. What is suffering but an emotion? Things, again, the prohibition against sowing terror, against exposure to public curiosity. The extent that emotional harm is or should be considered in distinction and proportionality analyses. This is linked to my fourth endeavor and track here is about emotions' influence in our legal interpretation and lawmaking. There's a rich body of literature on what are considered what are considered blended or thick concepts, and these are the concepts, for example, in criminal law, the reasonable person standard. We have so many thick or blended concepts within the law of armed conflict. Proportionality analysis is one of them. Feasible precautions. What is feasible? These are the concepts that requires much constant care, et cetera. Consent being arbitrarily denied for humanitarian aid. Exploring emotions' effect on the interpretation within those thick concepts, also from exploring the distinction or the differences between those who are making the interpretation and how their emotions, their goal-based emotions, are affecting their interpretation. And finally, this is also linked to, but I make a distinction between it and emotion in actual laws practice, how emotions influence really more on the tactical level, laws operationalization, and I saw that firsthand when I was practicing. We have some literature on this. Rebecca Sutton's, she calls them humanitarians versus soldiers and their perspectives on the ground of the law and how they're implementing it. The tendency of legitimacy of rules and of the law authority to allow actors then to ignore their own emotions and then, commit atrocities. So within my last probably minute and a half, how would this apply to the current conflict? For example, we've heard so many references to emotions yesterday and earlier today that this is probably second nature now. LOAC as an emotion producer in the Gaza war. We have lawfare of Hamas human shielding and comprehensive militarization of the Gaza Strip. to highlight, to produce suffering, to get individuals around the world to identify with the suffering and to decontextualize the overall operationalization, sterilization of the law of armed conflict by referring to its cold nature. Articles regarding proportionality saying, oh, well, law is cold, the law is cold, this is how it's done, I think is a component of lawfare, because lawfare does not always have to be pejorative. It's about using the law, I think, to produce a certain effect and emotions. Finally, we have also the influence of emotion on LOAC application, the fear of Hamas as an existential threat, or the identification and realization as an existential threat in Gaza war on the proportionality analysis. And I heard bits of this in Roni's terrific general's presentation yesterday. Saying, oh, but that's not what happens here. The emotional construct in killing of escaped and surrendering hostages. How did emotions play in that tragedy? The role of anger and humiliation and LOAC compliance and capture and detention settings. Finally, the third trajectory could be the influence of, or is, influence of emotions on interpretation. The role of emotions when you compare the ICRC's condemnation and interpretation of the rules regarding siege warfare versus United States, Israel, etc. I won't read this to you except for the very last one. International law is not about something else. It is the something. Words in the right order make us feel differently about the world. Because I feel that so much of my research and some of the cognitive neuroscience seems to make it seem that everything is relative, but it's not relative. And the words that we use represent constructs, and these are often emotional constructs that have similarities and that can be taught to each other. So thank you. Thank you for your help. I would love your feedback and your assistance with this project. Thank you.
Okay, so thank you very much for 3 interesting and hopefully will provoke a lot of questions. So I'm inviting you here.
Thank you all for that very interesting session. Obviously, Alan gave me great compliments in mentioning my work, but I'd like to make one clarification and ask you a question. First of all, you mentioned the question of reprisals, but I don't think you can have a general question of reprisals, because it's quite clear that reprisals against the civilian population are totally outlawed. This is in the first additional protocol to the Geneva Conventions, and it is, I admit it's problematical whether the absolute prohibition is part of customary international law, but it's generally considered that it is, with the kind of reservation of Britain to be taken into account. But that does not apply to other reprisals, and there can be reprisals which are not against the civilian population. And the article that you mentioned, in which I dealt with some reprisals, my assumptions were that reprisals have become outlawed in international law following the UN Charter, which restricts the use of force. But my basic question is to you, why is this relevant? I did not understand at all what you're referring to when you refer to the Gaza law. It wasn't at all clear to me, because at least Israel purports to be acting according to the Hague and Geneva law. And we no longer really admit to this distinction between Hague and Geneva, which I think is unfortunate. It's all in the kind of label of either the law of armed conflict or IHL. But it was not clear to me why you think there's a special category of Gaza law and what characterizes it.
Thanks very much. So my question is to Rachel, and I really enjoyed this. It was really interesting. And I know the kind of reference points that you've had were on international law and particularly on IHL. And so I don't know whether you're able to speculate more broadly, but I was wondering how prevalent some of the characteristics that you outline are in law more generally, or as you were, I would say whether IHL, whether even within international law, there are certain characteristics that make this more prevalent. So I would have thought, even in the wider discourse around, law being made by a relatively small number of actors who do it in a very public way, often in negotiations where they need to justify or legitimate why they're using law in this area to constrain actions that is otherwise perceived as political, whether that almost forces a need to be emotional about why you're doing it, and perhaps also whether adding, and this perhaps is a cynical perspective, but I'd be interested in your thoughts, whether bringing in, whether kind of, as you were, acknowledging the need to be emotional in decisions is a form of removing a constraint, because otherwise, if rules are not subject to emotions, as it perhaps would be when somebody's making a decision whether to give a tax deduction or to authorize a planning permission, but it is there present when you're making a decision whether to bomb a building, then that serves as a removal of constraint.
Thank you. My question is to Rachel. So you mentioned with a big assertion that the law of war is cold, but when we see most of, like, normatively at least, most of the IHL treaties, like, they have like principle of humanity or so many principles that reflect emotion. So in that sense, isn't it the practice of states that make IHL called than the normative rules themselves? And related to that, in recent times, in conflicts other than Gaza or in other conflicts happening around the world, including in Sudan, in Ethiopia, like I see a growing kind of views by actors, quickly classifying something as genocide and emotively, classifying something as a genocide. For example, from Ethiopian recent conflicts, I find conflicting views among different ethnic groups, like claiming that their ethnic group is a victim of genocide. Like while apparently, like if you fact check or whatever, you couldn't find that. So is emotion driven way of interpreting IHL or laws of war make us a bit uh, you know loaded and make our the conscience of judges a bit irrational. Yeah, thank you.
Thank you. My question is to Yair. I guess it's a question about how useful this methodology can be. Because I was going to ask, I mean, occupation is one thing, but it matters whether it's just occupation of land or also of people and how the people are treated. So I was going to ask, did you control for apartheid? Right. And of course, what that shows is that you need to make decisions like whether you want pre-application of ChatGPT and regression methods. You need to decide whether it's an apartheid regime. If so, it should you should probably compare it only to other apartheid regimes or things that are close. If not, they're not. And with that kind of stuff, I don't see how the methodology helps.
All right, well, thanks very much. So my question is to Rachel. It's a fascinating project. But one of the arguments for the use of autonomous weapons is that because of lack of emotion, they can be more accurate, so we should use them more. So I don't know how you can respond to this argument, and also about the use of artificial intelligence in warfare. Thank you.
Thank you. My point went to Yair about the variables that you were looking at. It really caught me a bit by surprise, the ones you had there. And if we really wanted to compare like with like, perhaps remove things like the nuclear weapons, yes or no, and look at, let's compare countries that are in armed conflict. If you could pull that out as a variable, I think that would be far more meaningful than others. It would have been nice to be able to tinker with your presentation as we tinkered with Rachel's.
My question is to Yair as well, and I think that I can agree that double standards are important, but I think that there are different ways to think about double standards in this sense, and it close to the question of what does silence mean, right? So we have two options to look at this. If we accept the methodology and everything, we see different treatment, but what is the other side? Is it that Israel violates the law and the other states also violate the law but are not condemned, or that there's a different treatment of similar action as lawful versus unlawful? And I think that your research does not answer this question, and I think that it's key to understand the importance of this double standard claim.
Just very quick, also goes to Yair. So you mentioned that you prove sort of the double standard, but what is a double standard?
Thank you for your questions, Professor Kretzmer. The question is a pretty good one, which is what is Gaza law? And the description of Gaza law comes to describe the gap between the doctrine of international humanitarian law as it is described in Geneva law. So if you don't think that there's a problem there because the Israeli military and Dablas consistently claiming that they're complying with international humanitarian law. So that's the law that they're complying with. And in fact, well, they're claiming that there's no reason for a new paradigm. We have a paradigm, it's Geneva law, and we're in compliance with that paradigm. And I'm saying that's silly. And the reason why that's silly is because if you look at every other country in this world, they're saying, no, you're not. And if you have to take that as a fact, it's a fact that everyone else is looking at saying, no, you're not. And so I'm saying, well, if so many people are saying that, if so many intellectually honest people are saying that, then there's a gap between the vast majority of people and what they're saying we're doing and what we're saying we're doing. And I'm saying that there might be a better way to describe it. And the reason why I'm saying that is because I think that the existing doctrine intentionally doesn't account for certain things because they're being articulated by people who don't want them to say those things. It's not a conspiracy theory. That's what they're saying. And so you don't have to call it Gaza law. You can call it the Israeli interpretation of Geneva law, but I don't think that that does enough.
A few thoughts. One on like apartheid or things like that. Yeah, that's a good variable. Like that's kind of the point. One thing I found that's interesting is that there's often more examples than you think, and that is that is valuable. In terms of armed conflict, it's in there. Both fatalities and like intensity, and it turns out it had less of an effect than I thought. Going back to kind of what is a double standard, and what does it mean? So the only thing I can really say is a double standard is when similar conduct is treated differently. That does not tell us whether who's right. It tells us that things are being treated differently. I think that that's relevant. It's not the only thing we want to know, but I do think it is relevant in the real world, where everyone should be. We should have the right treatment of everything, but in a place where resources are limited, nothing is treated exactly right, and we need to take into account of how you generally treat something. So I think that that's valuable, even if that's not, decisive.
Thank you so much for your comments and questions. Nicholas, I'll go in reverse order. I think that's a fascinating question, and I think it's something that I really need to. We had this discussion over dinner the other night. The role of whether autonomous weapons and artificial intelligence, do they, lack emotion, at least under the current definitions, leading definitions of emotions, and that's yes. Does that make them better, per se? Better for what? For what decisions? And were there emotions, and I would argue there were emotions involved in their establishment and writing of the software and the programs that are their guts, so to speak. But I think that's it's a fascinating question, and one that can't be ignored, and it deserves greater. It was even just acknowledgement. And I forgot your first name, sir. I'm sorry, but your points of I agree with you. I don't think the law of war, the LOAC IHL is cold. I said I think that's a myth, and that's one of the things I wanted to challenge, is that by calling it cold, we're missing a greater understanding that emotions are actually part of the law, and part of how we talk about the law, interpret the law, and what law actually is. And it's, in fact, the term cold has been associated with reason in literature and philosophy and ethics and the law. You can even find it in Supreme Court Justice Brennan's article about he wanted to bring passion back into judicial decision making. He said versus the cold, hard precipice of icy precipice of reason. And so I'm trying to say that's false. It's not cold. It's not just reason. It is emotion. And that the law of war as cold is actually a myth. And I think your example of genocide and the fact that that our emotions are conceptual constructs that we categorize using words, and that the word genocide is highly, highly emotive, and it is thrown out intentionally to produce emotions in the listeners, and that is in fact, and you can call that lawfare, you can call that the use of the law, or you can say that's a violation of the Genocide Convention as as that's an effect of the law affecting emotion. I very much agree with you on that. Decision making is, and Ruvi, coming to you because of the hardest questions, is recommending that the role of emotion be recognized in decision making, actually removal of a restraint. And I mean, I challenge the premise of the question, because that says there is a divide between reason and emotion, and that you actually can take out emotion, because my premise by definition is you can't take out emotion from decision making. It's there, and we ignore it at our peril. And in fact, I think it can improve decision making by recognizing the role that it actually does play. And comparatively across law, I teach usually 150 students every fall. United States criminal law, or in criminal law theory in general. And, that's one area in which there's been greater attention to emotions and the acknowledgement of emotions in criminal law, both by emotions of the decision makers, judges and jurors, as well as the role of emotions within the law itself, such as heat of passion defense and voluntary manslaughter and then first degree murder being the cold, calculated murder, and the emotional role there. But I think you have yes, I think this is applicable to all law, number one. Number two, do I think there's, because I practice and I still write and I'm teaching IHL or LOAC, I do think there's a particular valence here. I think because it's one of the areas of the law where it's been held on so much as this is the objective taming, objective winning and success of objective neutral law over the passions and the raging red hot emotion of war. And I really want to explode that dichotomy. So thank you. Thank you for this.
Okay, so thank you very much.